Initial interest confusion is a gloss on likelihood of confusion that has gotten a lot more attention in the internet era. But initial interest confusion precedents actually predate the internet. And so cases involving Steinway pianos and Mobil oil, and this idea that sometimes you can have confusion on the part of potential buyers that is dispelled before the point of sale, but is nonetheless actionable. And what's kind of interesting is that even though you see cases involving pre-sale confusion prior to the internet, and in the context in which they arise, you can tell a bit of a story about how the alleged confusion might potentially affect consumers in a negative way. The use of the doctrine increases considerably once the internet comes along, even though the story of consumer harm becomes a good deal more tenuous. And to start, let's begin with the Brookfield communications case. One of those cases that if you write about trademark law, you've probably written a passage here or there about how poorly reasoned this case is. And it is a creature of its time, and it's one that the Ninth Circuit has largely moved away from. Nonetheless, it remains good precedent and is kind of the foundational case for broad arguments concerning the scope of pre-sale confusion. And so let's talk about it just to kind of understand where the court was coming from. So the parties here involve a senior user, Brookfield, which makes software and databases. The junior user is West Coast, which is involved in videotapes and the like. And the mark in question is MovieBuff. And there are two issues at issue in this case. The use of the mark in domain names, which is not the part that we're worried about here, and the use of the mark in meta tags, which are this text that's invisible to the person using the internet, but is hopefully going to be read by a search engine and is going to aid the search engine in indexing a particular website in response to a query for the term that is described by the meta tag. Now, search engines, by and large, don't use these because, of course, there's a natural temptation on the part of website owners to kind of spam search engines with these kinds of meta tags to try to attract attention. And so Google, I don't believe, has ever used them, and they certainly don't use them now. No major search engine uses them. Nonetheless, we have all this case law that is built around this, this practice that makes very little practical difference, if any difference at all, in everyday life. And so it's kind of a funny road taken by the law to have a lot of important precedent geared around a practice that in practice is largely irrelevant, but here we are. So the theory of harm in this case is that the search engine will display sites next to each other, and there'll be sites that don't really have anything to do with each other, and therefore a searcher who searches on the term in question may be diverted and decide to go with the other site. And if that happens, and in this case, because Brookfield is deemed the senior user of the MovieBuff mark, if West Coast gets a click as a result of this kind of diversion, West Coast would improperly benefit from the goodwill that Brookfield developed in its mark. So we have this idea focused not so much on consumer harm, but rather on an anti-free riding rule, or this idea that Brookfield's goodwill should not be appropriated in this way by West Coast, even though we don't really have a very clean story of consumer harm. So what could be the story of consumer harm? And so the court has this billboard analogy. And they say, okay, well, let's imagine, and you have to go back in time when video stores were a thing. And so they say, okay, let's imagine that you have a billboard sign. And the billboard sign says, West Coast Video, 2 miles ahead at exit 7. But when you drive off the highway at exit 7, thinking you're going to go to West Coast Video, you see what's actually there is a Blockbuster. And that having been lured to the wrong video store, you may just shrug your shoulder and say, whatever, I'll just stay. It's not worth getting back on the highway just to find West Coast Video, even though that's the store that I actually prefer. Say it's raining, say it's late, you've got to get something home, whatever your reason. Having been lured, you might just stay. On this analogy, you can tell a story that is consistent with the purposes of trademark law. From the perspective of the senior user, right, you have this potential lost opportunity for West Coast, the senior user in the billboard hypothetical, and you have this idea that Blockbuster is taking a free ride, so to speak, off of West Coast's goodwill. And, leaving aside the concerns of the sellers, we can tell a story of consumer harm. The consumer may actually prefer West Coast, but may settle for the less attractive alternative, having expended the excess search costs to go to the wrong store. That insofar as the price borne by consumers is a combination of the price paid and the search costs, an elevation of search costs may make a consumer settle for a less satisfactory alternative. So say a consumer has a preference for West Coast over Blockbuster that is essentially worth a quarter, but the consumer values not getting back on the highway at more than a quarter. And therefore the consumer, having already found the wrong store, just decides, heck, I'm just going to stay here and I'll take the suboptimal outcome because I would rather not expend further search costs to go and find the actual West Coast video. And so even if you prefer it, just not enough to actually search for it. This idea that there's a bait and switch going on, and that's causing consumer harm. Now, of course, it's possible that this kind of bait and switch tactic could, in certain settings, be beneficial to the consumer. So for example, suppose Blockbuster is the upstart business, and by getting consumers to come into the store, they realize, oh my goodness, the selection here is actually better. The prices are actually better. And so there's a possibility that activities described as initial interest confusion, pre-sale confusion, bait and switch tactics, could potentially inform consumers of other possibly better options. Now, I think in the billboard hypothetical, this is not a great argument because of the significant costs of consumers of having expended search costs by driving on the highway and going to the wrong store. But it should signal the possibility, though, of what happens if the search cost expenditures are not nearly that large. And it's important to keep this possibility in mind because if the consumer ultimately prefers the alternative, ultimately prefers the junior user, then the senior user's goodwill in that situation is not actually that valuable insofar as a non-confused consumer may choose an alternative product. And so here we have to kind of find a way to weigh the costs and benefits to hurt and benefited consumers. And it seems to me that the metric to look at is actually the search costs. And it's the case that not everything that is alleged to cause initial interest confusion is in fact going to result in increased search costs. And so you see this in the everyday world, right? If you think about something that, you compare this idea of a false billboard, which everyone agrees should be actionable, if not under trademark law, then under false advertising law, versus something like drug packaging. And when we think about drug packaging, we see all the time on store shelves, companies like CVS or Walgreens offering store brands to consumers that use similar coloring, similar packaging to the name brands. And so they market their generics using similar color schemes. Why? To signal to consumers that my product is like Tylenol. My product is like Aleve. My product is like Advil. And naproxen sodium for Aleve, acetaminophen for Tylenol, and ibuprofen for Advil are all cheaper alternatives to the brand names of the generic drugs. And using similar color schemes, it's an efficient way to communicate to the consumers which ones are the generics. Now, it's entirely possible that a consumer who is in the market for Tylenol and only Tylenol, or Aleve and only Aleve, or Advil and only Advil, will reach for one of these store brands and upon looking at the label, see that it's actually not the thing that they're looking for and put it back. And if that diverted reach is produced by the copying of the color scheme, we could say that that's a diversion. We could say that that is an increase in the consumer search costs, but we could also say that in that context, the search costs are utterly negligible because it's just simply the cost of reaching for something on a shelf, looking at it, and putting it back. This is not being diverted by an exit on the highway. And so to the extent that this is some kind of misappropriation of goodwill, we can question whether or not the goodwill actually has any real value. And this takes us to a critique of what's going on in Brookfield, because to whatever extent we may buy, and I'm not necessarily we necessarily have to, but if we buy the theory that there's a diversion by listing the West Coast video site next to that or proximate to that of Brookfield, the fact is that once you land on the West Coast video site, there is no meaningful increase in search costs because you see immediately that you are not at the Brookfield site if that's where you really want it to go. And if that's where you really want it to go, you backclick and there's no real issue. And so aren't there competitive reasons for using marks as meta tags, or again, not so much, an irrelevant practice like meta tagging, but now thinking about relevant practices like the purchase of keywords on Google. Aren't there competitive reasons for doing this kind of thing, insofar as trademarks can be information-rich terms? If I'm in the market for acetaminophen, and the reason I'm in the market for acetaminophen is because I took Tylenol as a child, and I know there's such a thing as a generic. Tylenol is actually an information-rich term, even though it's not a generic term, even though it's still a brand name that gets protection as a brand name. It may be useful to me as a consumer to say, I want generic Tylenol. I'm not, I understand that there is a brand name called Tylenol. That's not what I want, but I want something that is the same as Tylenol, but is cheaper. And it is easier for me to remember and use the term Tylenol than it is for me to use the term acetaminophen, which, I can tell you from having written, enough law review articles and the like that have, made this example. I can never spell acetaminophen correctly. And I've been, at this for over 10 years. And I think the next time I spell it correctly on my first pass will be the first. And Tylenol, however, is exceptionally easy to spell. And so a Google search for that word may be more useful to a consumer than simply saying something like pain reliever, because the consumer may specifically want acetaminophen and not the active ingredient of Aleve, naproxen sodium, or ibuprofen in the case of something like Advil. In terms of meta tagging, Brookfield was kind of obsolete almost from the get-go, but the real cash value of the precedents that come out of Brookfield is what happens to defendants like Google, what happens to defendants like Amazon if they respond to search inquiries on trademarks by listing products that are not the trademarks, but that Amazon still carries. Is that something that is potentially going to be actionable? And so here we do have a decent amount of litigation since Brookfield on those questions. And we see here, again, one of those cases in the law where there's this conflict between the consumer welfare and goodwill protection rationales of trademark law. And the question of which interests ought to give way. And can these rationales be harmonized in the initial interest confusion context? And so, again, I tend to think that this is one area where the search cost theory actually is quite useful. And we could kind of think of what goes on in an initial interest confusion case as almost being a form of point of sale confusion, but the purchase is a closer look at the product, right? That I'm going to take that highway exit and look at West Coast Video. I'm going to click on that link and see what website is there. I'm going to reach for that medicine on the wall. And if the search costs are high, then there's a value there, and there's a misappropriation of goodwill that we ought to worry about. But if it's low, then nothing of value is really appropriated, and the enforcement of trademark rights in that setting is an endangerment of competition. This really does seem an area where a clearer focus on which consumers are harmed, how they're harmed, and a comparison to potential consumer benefit is really useful. Now, Brookfield is not a case that engages in that thinking, but in a future lecture, we're going to talk about the Amazon MTM case, where the theory of initial interest confusion is significantly curtailed by the court, and there's a much deeper appreciation of conflicting consumer interests. And it's worth noting that the Brookfield theory is in decline in general. Google is generally successful in litigation concerning keywords. However, we don't have rulings that dismiss the doctrine altogether. And so it's kind of still out there, And sometimes, sometimes courts just say, well, we're not going to do this here. Maybe if the plaintiff gave us more evidence or that sort of thing. But the interim effect or the potential interim effect of the theory in some contexts is still quite present. For an example of a case, curtailing the theory, also from the Ninth Circuit, we have Network Automation Incorporated versus Advanced Systems Concepts, Inc. And this is a case involving keywords. And here the defendant uses the plaintiff mark as a search term for advertising, and the court reverses a preliminary injunction in favor of the plaintiff and makes an important clarification that's missing from Brookfield. And that is that the issue is confusion. The issue is not mere diversion. And so the court here, interestingly, applies the multi-factor test and says, well, these days, Brookfield was one era of internet law, but you know what? Consumers are more sophisticated now. That's going to make us reluctant to just simply assume that there's trademark infringement here. Deliberate selection of a mark is not the same thing as bad faith. And if we're going to think about keyword advertising, what we need to do is we need to consider the actual context of the ads. Do they do anything in the way they're displayed or the like that is going to cause any likelihood of confusion? And so we're going to remand this to the district court. And when they do that, they should think about the strength of the mark, which again, this factor always has, the potential for mischief in cases when we're not dealing with competing products. It should consider whether there's any actual confusion. It should consider the type of goods and the degree of consumer care. And here again, importantly, the labeling and appearance of the advertisements and the surrounding context. And so, to my mind, that sort of is a signal that cases like this in many circumstances are really about false advertising and not so much about, traditional trademark confusion. But one thing this does do, while, it arguably makes the multi-factor test yet more complicated, it kind of acts as a corrective to this problem we've been seeing in non-traditional source point-of-sale cases, which is the possibility that as we get away from sort of the traditional trademark infringement cause of action, we had this problem that we identified that courts weren't considering distinguishing context, things that tended to make likelihood of confusion less possible. And so here we have the court actually signaling, no, let's try and consider the surrounding context. Let's ask whether or not a likelihood of confusion really is likely given that context. And that, at the very least, for whatever it does to the consistency of the multi-factor test, is a welcome corrective to what I think in many cases has been the court's oversimplification of the question in the context where that oversimplification in favor of the plaintiff was less justified by the claims at nature rather than being more so. And so we'll leave it there. Thanks very much.